Sound check, 1, 2. Okay. That was just you could have said.
Oh, iba red.
Oh,
Apa that? Oh, pindah. Ile, yes. No fetsa ba.
Good morning, honorable members. I just want to, before I say anything else, to express my sincere apologies for the delay. We were held up at the hospital corner there, and there was a small accident involving a minibus, and you may be aware how those guys react in such small accidents and small things. So I just want to apologize for the delay. Good morning once again and welcome in the new year. This is our first physical meeting in 2025. So it is perfectly in order for me to compliment every one of you in the new year and wish you all the best in your endeavors in the new year. We have our guests here, whom we had actually invited. We have Mr. Simani and Ms. Ngema. I think they both come from the Parliamentary Legal Services. We have from the department the Deputy Director General, Mr. Ndobe, whom I want to recognize, and his team. Honorable members will recall that at some stage we actually discussed the whole issue of seeking legal advice around the issues that we are confronted with regarding the Ingonyama Trust Board. Indeed, we then approached the Parliamentary Legal Services to actually educate us, if that is the right term, on the legal intricacies around the operations of Ingonyama Trust. And why we actually wanted to do that was actually part of our fact-finding mission, because so far as this committee, we are actually collecting as much information as we can, and we are actually educating ourselves as much as we can on all the intricate issues surrounding the operations of Ingonyama Trust. So that therefore the opinions that we actually sought from the legal services will be legal opinions, as in the true sense of the word, and we will be free to interrogate the report, ask questions of clarity, and this is a report that would be an opinion from the department based on the current legal framework within which Ingonyama Trust actually operates. So without any further ado, I would like to give the opportunity. First, I accept the apologies, if any. Yes, may I recognize Honorable Nana?
Thanks, Chairman, and thanks for the opportunity. On apologies, I realize that the so-called progressive caucus is not here except for Honorable Matthias. Could this be an act of sabotage? Does he want to share some information with us?
Thanks a lot.
Hello, Chair.
Yes, Honorable Chair.
Other comments and statements are not worth commenting. Can we proceed with the meeting now?
Thanks, Chair. Good morning, members. We have apologies from Mr. Mnetama and Mr. Madlala. They are attending an emergency caucus meeting. And also an apology from Dr. Mahlatsi. And there's an apology from the Honorable Minister Nyonso. Thanks.
May I then hand over? Well, we all received the agenda, isn't it? Yeah. So there hasn't actually been any changes on the agenda. So may I then give our colleagues from the Parliamentary Legal Services to make a presentation. Okay, maybe before that, Honorable Adams. Oh, thank you. Honorable Adams is reminding us that we actually have not adopted the agenda. She is actually proposing that the agenda be adopted. Is there any seconder? Or I recognize the hand of Honorable Nana seconding the proposal. Can I then call upon the Parliamentary Legal Services to make their presentation? Did you press your mic? It's a very fancy one.
Okay, is it on? Okay. Thank you, Chairperson. We will be presenting an opinion on the challenges that are within the framework of the governance of the Ingonyama Trust. The Constitutional and Legal Services Office was requested to advise the Portfolio Committee on Land Reform and Rural Development on how it should respond to the governance challenges at the Ingonyama Trust Board. More specifically, whether the Ingonyama, who is the sole trustee of the Ingonyama Trust and the chairperson of the board, has the powers to suspend the members of the board or disband the board. Our office was further requested to provide an insight into the legal foundations of the Ingonyama Trust and the board and how the trust differs from other ordinary trusts. Now, therefore, the legal questions to be considered in the context of the administration of the trust are therefore the following. That is the legal foundation of the trust and the board, ownership and vesting of the trust property, and how the Ingonyama Trust differs from other ordinary trusts, the powers, if any, of the chairperson of the board, who is also the sole trustee of the trust, to suspend the members of the board or disband it entirely. Whether a member of the board can unilaterally institute a forensic investigation into the affairs of the board. The Portfolio Committee further inquired if the impasse in the administration of the board continues and is prevented from doing its work, what legal recourse, oversight, and accountability mechanism are available for the committee to address the situation. Furthermore, the committee requested advice on legal and parliamentary procedural questions, if any, that the committee should consider as it envisages engaging with the chairperson of the board. The Trust Property Act of 1998, which is Act 57, is the general legislation that regulates the control of trust property and related matters. With regard to the furnishing of security in terms of Section 6.2 of the Trust Property Act, the master does not grant authority to the trustee in terms of this section unless A, he has furnished security to the satisfaction of the master for the due and faithful performance of his duties as trustees, provided where the furnishing of security is required. The master may pending the furnishing of the security, authorize the trustee in writing to perform specified acts with regard to the trust property. Section 12 of the Trust Property Act stipulates that trust property shall not form part of the personal estate of the trustee, except insofar as he, as the trust beneficiary, is entitled to the trust property. The Ingonyama Trust was established in terms of the then KwaZulu-Natal Ingonyama Trust Act 3 of 1994, which is the Trust Act. In terms of Section 2.1 of the Trust Act, the Ingonyama Trust is established as a corporate body with perpetual succession and power to sue and be sued, and to do all such acts and things as bodies corporate may lawfully do, subject to the provisions of the Ingonyama Trust Act. Section 2, subsection 2 further states as follows in the establishment of this legal entity. The trust shall, in a manner not inconsistent with the provision of this Act, be administered for the benefit, material welfare, and social well-being of the members of the tribes and communities as contemplated in KwaZulu Amakosi and Iziphakanyiswa Act number 9 of 1990. Section 2.3 of the Trust Act stipulates that the Ingonyama is the sole trustee of the trust, which shall be administered by the Ingonyama. The Ingonyama is defined as the Inkosi of the Zulus and is also known as the King of the Zulus. The Ingonyama or Isilo, or may also be a person, acting on behalf of the Ingonyama. In terms of Section 2.6 of the Trust Act, the Ingonyama as a trustee is exempted from furnishing any form of security, and the provisions of the Trust Monies Protection Act of 1934 and the Trust Property Control Act of 1988 shall not apply to the Ingonyama as a trustee or to the Ingonyama Trust established by Section 2.1. The board is established in terms of Section 2(a)(1) of the Trust Act, with Section 2(a)(2) settling the following parameters for the board. The board shall administer the affairs of the trust and the trust land, and without detracting from the generality of the aforegoing board, the board may decide on and implement any encumbrance, pledge, lease, alienation, or other disposal of any trust land, or of any interest or real right in such land. Section 2, capital letter A, subsection 3 of the trust determines the composition of the board. Quote, the board shall consist of A, the Ingonyama or his or her nominee, who shall be the chair of the board, and B, 4 members appointed by the minister after consultation with the Ingonyama, the premier, and the chairperson of the House of Traditional Leaders of KwaZulu-Natal, and C, 4 members appointed by the minister with due regard to regional interest, in consultation with the premier, who shall consult with the Ingonyama and the chairperson of the House of Traditional Leaders in this regard, close quote. Furthermore, subsection 2A7 of the trust enables the minister to make regulations which deals, among others, with the powers and duties of the chairperson, the vice chairperson, and acting chairperson at meetings of the board. Pursuant to this provision, the KwaZulu-Natal Trust Administrative Regulations of 1995, that is, the regulations were promulgated. The regulations define the chairperson of the board as the Ingonyama or his or her nominee presiding at the meeting of the accounting authority, or in his or her absence, the vice chairperson or acting chairperson, as the case may be. Within this context, any reference to the accounting authority means the board as defined in the regulations. Regulation 3 of the regulation sets out the ground on which a member of the accounting authority, that is the board, may vacate his or her office. In terms of Regulation 3, paragraph H of the regulations, a member may vacate his or her office if he or she is removed from office by the minister, where the latter is of the opinion that sufficient reasons exist for such termination, and after he has consulted in the manner described in section 2 cap A3, B or C of the Trust Act. It must be further noted that in this context, any reference to the minister means as the minister as defined in the Trust Act, that is the Minister for Agriculture and Land Affairs of the national government, or another minister designated by the President. Section 215 of the Constitution of the Republic of South Africa of 1996 envisaged a legal framework to regulate the financial management of public entities and promote transparency and accountability. The Public Finance Management Act 1 of 1999, that is the PFMA, accordingly provides the envisaged legal framework for the financial management of public entities. The principal purpose of the PFMA is to regulate financial management in the national government and the provincial spheres of government. The Ingonyama Trust receives public funds and therefore must account for these funds within the framework of the PFMA. In terms of the PFMA, the board is a Schedule 3A public entity. Now, coming to the discussions regarding the ownership and the vesting of the trust property. In Section 1 of the Trust Property Act, a trust is defined as the arrangement through which the ownership in property of one person by virtue of a trust instrument made over or bequeathed be to the beneficiaries designated in the trust instrument, which property is placed under the control of another person, that is the trustee, to be administered or disposed of according to the provision of the trust instrument for the benefit of the person or class of persons designated in the trust instrument, or for the achievement of the object stated in the trust instrument. It must be stated that the Ingonyama Trust is distinguishable from other ordinary trusts insofar as the requirement for trustees to furnish security. The Trust Property Act requires trustees to furnish security deemed sufficient by the master to ensure the due and faithful performance of their duties in terms of the trust deed, unless exempted from same in accordance with the trust deed. However, in terms of Section 6.2 of the Trust Act, in dealing with any property, any trust property, the Ingonyama as a trustee is exempted from furnishing any form of security, and the provision of the Trust Property Act do not apply to the Ingonyama as a trustee or to the Ingonyama Trust. As stated above, trust property may not form part of the trustee's personal estate unless he or she is the trust beneficiary and is entitled to the trust property. In other words, trust assets, albeit legally held by the trustee under bare ownership, do not form part of the trustee's personal estate. In common law, the trustee has a fiduciary duty to administer the trust to the benefit of the beneficiaries and thus not entitled to the property of the trust except in circumstances where he or she is the trust beneficiary. In the case of Ingonyama Trust, it is administered by the Ingonyama as a sole trustee and the board for the benefit, material well-being and material welfare and social well-being of the members of the tribes and communities contemplated in the KwaZulu Amakhosi and Izipakanyiswa Act. In simple terms, the trust beneficiaries of the Ingonyama Trust are the members of the tribes and communities as identified in Section 2, Subsection 2 of the Trust Act. The trustee and the board have a fiduciary duty to administer the trust to the benefit of the identified beneficiaries, that is, the members of the tribes and communities as referred to in Section 2, Subsection 2 of the Trust Act. In Robinson versus Randfontein Estates, gold mining, an appellate decision, the Chief Justice, in relation to the fiduciary relationship between the trustee and the trust beneficiary, stated that where one man stands to another in a position of confidence involving a duty to protect the interest of that other, he is not allowed to make a secret profit at the other's expense or place himself in a position where his interests conflict with his duties. This fiduciary duty is statutorily entrenched in Section 2, Subsection 2 of the Trust Act. Section 2, Subsection 5 provides that, quote, the Ingonyama shall not encumber, pledge, lease, alienate, or otherwise dispose of any of the said land or any interest or real right in the land unless he has obtained the prior written consent of the traditional authority or community authority consent, close quote. In the case of Kashak and others versus Ingonyama Trust and others, Deputy Judge President Madondo confirmed the position of the people living in the trust-held land, being members of the tribe and communities referred to in Section 2, Subsection 2 of the trust, as the true beneficial owners under Zulu customary law of trust-held land.
I'm sorry, Chairperson, and I'm sorry for doing this to you, sir. I just want to be clear. The use of the word Ingonyama, do you mean Ingonyama as Isilo? Every time you say Ingonyama and you not say Ingonyama Trust Board, am I correct to assume that you refer to Isilo?
Yes. Isilo,
Okay,
yes,
sure.
as defined in the
I was getting lost.
Okay, thank you.
I'm sorry.
Okay, all right.
Honorable Chair. Can we
Yes,
focus?
Honorable Martin.
Can we please focus? This point that the honourable member is raising as a point of clarity has been explained at the introductory notes of the present. So let's not be carried away by outside issues. Let's focus.
Your advice is noted, Honorable Member. Yes, I also remember that in the introductory, page, it was actually defined who the Ingonyama is, and so in the context of what we are discussing. Okay, would we allow the presenter to continue, honorable members, before we start, throwing Scud missiles and okay, can we allow him to continue? Thank you.
Thank you, Chairperson. In the case of Kashak and others versus Ingonyama Trust and others, the Deputy Judge President Madondo confirmed the position of the people living in the trust-held land, being members of the tribes and communities referred to in Section 2, Subsection 2 of the Trust Act, as the true and beneficial owners under Zulu customary law of trust-held land. The court declared invalid and unlawful all the residential lease agreements concluded by the trust and the board in respect of residential land or arable land or commonage on trust-held land with the members of the tribes and communities referred to in Section 2, Subsection 2 of the Trust Act. In view of the above facts and relevant legislative framework, it is right that the trustee of the Ingonyama Trust holds a fiduciary position and duty which requires him to always exercise his powers to the advantage of the beneficiaries and act within these powers. In terms of the CASAC judgment, it is right that the members of the tribes and communities referred to in Section 2, Subsection 2 of the Act are the beneficial owners under the Zulu customary law of trust-held land. Now, moving over to another question relating to the powers of the chairperson of the board. In terms of Section 2, Cap A, 3A of the Trust Act, read with Regulation 1 of the Trust Regulations, the Ingonyama or his or her nominee shall be the chairperson of the board. The regulations set out the powers and duties of the chairperson of the board. In terms of the Trust Act and the regulations promulgated thereunder, the chairperson of the board does not have the power to appoint, suspend, or dismiss the members of the board. Therefore, the powers and duties of the chairperson of the board emanate from and are limited to the provision of its enabling legislation. In other words, the chairperson does not have any powers other than those conferred by the Trust Act and the regulations. In terms of Section 2, capital letter A3 of the Trust Act, only the minister is vested with the powers to appoint members of the board after consultation and or in consultation with the relevant parties. Akin to that, only the minister is empowered in terms of the regulations to remove a member of the board if he or she is of the opinion that sufficient reasons exist for such removal and after he or she has consulted in the manner described in Section 2A, 3B or C of the Trust Act. As can be gleaned from the above, while the minister is empowered to remove a member of the board, such powers may not be exercised capriciously, but only after following a due consultative process. In Peshe versus Government of the Republic of South Africa and another, the court confirmed the principle that the power to appoint and conversely to dismiss has inherent in it the concomitant power to suspend. In this context, the power to appoint and by extension to suspend members of the board is an exclusive purview of the minister. Having due regard to the above facts, it is quite evident that the chairperson of the board is not empowered in terms of legislation to either suspend or remove any member of the board, and therefore he will be acting beyond the scope of his powers in suspending and removing any member of the board. The question that were also posed to the Legal Service Committee Department was whether a member of the board has the powers to institute forensic investigation into affairs of the board. As indicated above, a member of the board are appointed by the minister following a due consultative process prescribed in Section 2A3B or C of the Trust Act. That is the section that relates to the minister being required to consult with the premier and also with the Ingonyama, and also to in consultation with the premier who consult with Ingonyama. So that section provides for two scenarios: the appointment of 4 members of the board, where the minister is required to consult with the premier and with the Ingonyama, and another 4 members of the board, where the minister is required to appoint in consultation with the premier, who also consult with the Ingonyama. So similarly, when when the minister removes a member of the board, he has to undergo the same consultative process. Section 2A of the Trust Act stipulates that the board shall administer the affairs of the trust, may delegate or assign subject to such condition as the board may determine any of its powers, generally or in a specific case, to a committee of the board or a member of the board. The board is a public entity as contemplated in Schedule 3 of the PFMA. Section 49 of the PFMA further states that every public entity must have an authority which must be accountable for the purposes of this Act. And if the public entity has a board or other controlling body, that board or controlling body is the accounting authority for that entity. Moreover, Section 50 of the PFMA imposes a fiduciary duty on the accounting authority, that is the board in this instance, among others, to ensure the public entity has and maintains effective, efficient, and transparent systems of financial and risk management and internal control, and a system of internal audit under the control and direction of an audit committee. The board and accounting authority is, in terms of legislation, entrusted with the responsibility of ensuring that there are proper systems in place for efficient running of its affairs. It must be noted that the board members collectively execute its fiduciary duties in terms of the PFMA, unless in its sole discretion it delegates or assigns any of its powers to a committee of the board or individual member of the board, as contemplated in Section 2 Cap A of the Trust Act. Therefore, an individual member of the board does not have the powers to institute forensic investigation into the affairs of the board unless expressly mandated to do so by the board. The Portfolio Committee also sought an advice on the legal recourse on and oversight accountability mechanism to address the impasse in the administration of the board, if the impasse in the administration of the board continues and it is forbidden from performing its duties. As indicated above, the decision of the chairperson to suspend or remove a member of the board is ultra vires in its ambit. That is, ultra vires meaning that when a person is acting outside the scope of his powers. The legal recourse to remedy the situation is to file an application to review, seeking to have the decision of the chairperson declared invalid and set aside. That is the legal recourse that is available if one were to challenge that decision. Regarding the oversight and accountability mechanism, in terms of Section 55 of the Constitution, the National Assembly, and by extension its committees, is vested with a constitutional mandate to maintain oversight of the national executive and over all organs of state. Section 92 of the Constitution empowers the National Assembly to hold the executive accountable. Parliamentary committees are an established mechanism that fulfill the Parliament's oversight and accountability mandates that flow from the Constitution and the National Assembly rules. Rule 167A of the NA rules provides that for the purposes of performing its function, a committee may, subject to the Constitution, legislation, the other provision of these rules, and the resolution of the National Assembly, may summon any person to appear before it to give evidence on oath or affirmation or to produce documents. In the case of EFF versus the Speaker, the Constitutional Court held that Parliament had failed to discharge its oversight role by not holding the President accountable by ensuring that he complied with the remedial action taken against him by the public protector's report. In this matter, the overarching constitutional mandate of the Portfolio Committee is to ensure accountability and exercise of its oversight functions. The Portfolio Committee may therefore invite any person to appear before it to account for matters that fall within the Portfolio Committee's area of oversight. If any person refuses to account in exercises its functions, the Portfolio Committee is empowered in terms of the NA rules to summon any person to appear before it. Regarding this matter, the Portfolio Committee is vested with the power to request the Chairperson of the Board to appear before it and account on the affairs of the Board. In conclusion, in view of the above facts and legislative framework governing the Ingonyama Trust and the Board, it is our view that the Chairperson of the Board acted beyond the scope of his powers in suspending a member of the Board, as such power to appoint and suspend members of the Board is vested with the Minister. The Portfolio Committee is empowered in terms of the Constitution and the National Assembly rules to request the Chairperson of the Board to account for the affairs of the Board as a public entity listed in Schedule 3 of the PFMA. We so advise. Thank you, Chairperson.
Thank you. Thank you very much, legal advisor. Well, honorable members, this is the legal opinion that we had actually sought from the Parliamentary Legal Services in regard to the issues that are actually listed there, as we wanted clarity on them. As I have actually emphasized earlier on, this is the opinion, legal opinion from the Parliamentary Legal Services. It is not our committee, this is not our opinion. The conclusions are the legal conclusions arrived at by the legal services. These are not our conclusions, and therefore I would actually, open the discussion around the report that we actually have been given. Members would be free to ask clarity-seeking questions and even to comment on some of the legal points that actually have been raised. Okay, I will recognize the hands of honorable members. Honorable Matthias. Honorable Matthias.
Thanks so much, Honorable Chair. Let me welcome the presentation from the Parliamentary Legal Office and hasten to say that the legal advice is indeed comprehensive and will resolve many of the unclear matters in relation to the impasse that we're faced with, and we have been dealing with for the last about 3 months. But, Honourable Chair, allow me to raise this, that one question under the legal questions, there are a couple of questions under page 2, legal questions, and there's a list of questions that are raised there. One important question which should have been raised and was not is that, I don't know if there would be an answer to this question, is that what happens should there be a vacuum as a result of the impasse in the operational function of the Ingonyama Trust Board, and what are the legal or administrative mechanism to deal or to deal with the vacuum as a result of the impasse. As we speak now, the Ingonyama Trust Board members have been barred from entering the premises. The CEO and the Chief Financial Officer and other officials have been stopped from accessing the premises and the offices. In a case like that, which has resulted into a vacuum because of the impasse, what mechanism are in place, or what legal opinion our brother here can offer in this regard? Thanks so much, Honourable Chair. I'll come later. I just wanted to raise this as one of the most important questions which should have been raised so that we can get an answer for.
Thank you. I don't know how you want to handle that. Would you like to allow, are you keeping notes of what they're asking?
Okay.
And then so that at the end,
Okay.
then you can respond comprehensively to all the questions that would have been given. Then the next one would be Dr. Posho, Honorable Posho.
Thank you, Honourable Chair. I would, just by way of background, want to know, I hope you don't see that beyond the scope. Honourable Matthias is a little bit
Can you
strict.
please use your mic?
I thought I do. Okay, maybe it's a little bit better. Honourable Matthias is a little bit strict on what one can ask in the discussion, so I hope I don't go beyond those limits. But I just by way of background, is this a new problem that or a new situation, a new dispute with a new king? Or had there been similar disputes previously with a previous king? Thank you.
Then Honorable Dalane.
No, thanks, Chairperson. I think on the issue of the legislation guidance, is there any legislation guidance to address the situation where there is a breakdown of trust between the trustee and the board or the board members? What must happen? And also on the question of beneficiary official ownership, does that mean that the owners are beneficiaries although the trustees hold the property legally?
Thank you, Honorable Dalane, and Honorable Nana, and then Honorable Matthias.
Thank you very much, Chairman. The first question I have, and I'm aware that you are not the crafters of the Constitution, so I may actually ask you a question that you may not be able to respond to it. On the appointment and removal of board members, and that will be bullet point number 10, section 2A, subsection 3. What could what could have been the rationale behind? Because to me, the minister is required to consult with the king, the premier, and the chairperson of the House of Traditional Leaders in KZN to appoint 4 members. And again, the other 4 members, the minister is expected to consult the premier. In return, the premier consults the king. What could be something isn't making sense to me. It would seem we are doing all of the same thing. I mean, it doesn't make sense. Why would you want to consult the king for the first 4, and for the second 4, you delegate that consultation to the premier, for lack of a better word? And secondly, on bullet point 43, it is my understanding that the king of the Zulu nation is the owner of the land. And you'll correct me if I'm wrong. Now, we are, as the portfolio committee in bullet point 43, we are basically saying we can hold someone accountable for something that he owns. Is it possible? Please, can I be clarified? And I do know that this question, you are not asked to give a legal opinion on it, but can I sneak it in if you'll allow me? There's an entity called Ingonyama Holdings, am I correct?
Yes.
There is an entity called Ingonyama Holdings.
Only you could use your mic.
Oh, sorry. As I said, there is Ingonyama Holdings. What is its legal standing? How does it fit into this whole situation? Thank you.
Thank you, Honorable Natili.
Chairperson, let me also thank the presenter for really giving us the information that I think will be important as we are about to embark on this oversight visit. Maybe the question of clarity for me, Ingonyama Trust was established in terms of the KwaZulu-Natal Ingonyama Trust Act of 1994. And then you have the Interim Protection of Informal Land Rights Act. I would like to understand what is the relationship between the two. Because, I mean, while Member Nana is saying the king is the owner of the land, does the king really own the land? That's a question here. Because here's the quagmire in this conflation of acts. You have the sole trustee of the land on behalf of the beneficiaries of this land. And the beneficiaries of this land look up to the sole trustee to make decision on their behalf. And yet the powers rest with someone who does not enjoy the same confidence of the beneficiaries, which is the minister. I mean, for me, that is a quagmire that we are sitting with here. And then perhaps the second last question. I see, of course, we are talking about the legalities here, but I think these legalities as well must have pragmatism, if I can put it that way. One understand and accept that in terms of the law, as things stand, the chairperson, who is the sole trustee, cannot fire the members of the board. And of course, those members have a legal recourse by going to court. But the consequences of that legal recourse has far-reaching implications. And I'm talking about being pragmatic here. I mean, let's say they win the case against the trustee, who's also the chairperson, who enjoys the massive support of his people. How do you correct that? Because they may, well, the court might rule in their favor. But if the trustee, who's also the chairperson, with his subject says, we don't want these people, what are we going to do? So that is why I'm saying this is really a conundrum that we are sitting with. That I think perhaps you must assist us in applying your mind. How do we deal with that? And lastly, Chairperson, I think this exercise really must assist us to do two things as we embark on this oversight visit. And of course, we accept the legal opinion, but I think we have a responsibility here to assist in making sure that this process is handled correctly for the benefit, of the beneficiaries, which are people under Ingonyama Trust. But secondly, it gives us an opportunity to really look at these acts very closely. There are practical implications going forward, and maybe find a way to synchronize them in a way that makes sense. When I refer to that matter of being pragmatic, because yes, law is a law, but the law must be pragmatic as well. When there's a legal recourse, you must be able to implement that legal recourse. And quite honestly, in this situation, I don't see how. Thank you, Chair.
Well, thank you so much, Honorable Matikizela. Then may I actually give the opportunity to Honorable Lucas?
Thank you very much, Chairperson, and good morning to those that I've greeted. And also let me welcome the opinion. That is why they are saying the more lawyers,
Honorable Lucas, have you forgotten to press your...
I have pressed it.
Okay.
So I don't know, I'm a little bit confused when I listen to particularly the issues of the determination of who is responsible or who can be the one that will be able to dissolve the board at any stage. Chairperson, like I said, this is the legal opinion, but in generally, what triggered where we are today is because of our observation of the state of affairs at the Ingonyama Trust. And it's fine that we have that there is a determination that only the minister can dissolve or do whatever in terms of the dissolution. And I don't know, maybe I'm saying the same thing that Honorable Matikizela have said. And I've also written here in the interest of the beneficiaries. And we have observed that the board is no longer handling issues according to our observation in the interest of the beneficiaries because of what is transpiring with issues of holdings and whatever. So at what stage then does the minister get involved? And how is it actually initiated that we have observed and the minister have been present, the minister have been there? This issue of Isilo, the action that he took actually came at the tail end of a process. Already observed that there are serious challenges within the issues of Ingonyama Trust. Now, I don't know who I'm asking this question to, but I am asking it. and I am asking myself, the actions of the chairperson of the board is being seen as abuse of his position. But in actual fact, if the chairperson of the board is trying to arrest the situation, what is then now the view? Outside of law or within common law, what is then now the view? And how do we make sure that the minister really took up his responsibility without getting into conflict with what is already happening? Because I see now the actions of the chairperson of the board seem to be in conflict with what is really prescribed. But at what stage do you really act when you see things is getting out of hand? I'm just asking a general question.
Well, thank you so much, Honorable Lucas. Honorable Mukaka.
Madam Chair. Good morning, honorable members. Let's welcome the presentation from the legal gurus of the Parliament. It's very comprehensive and it responds to many questions that I always had about the role of these trusts, particularly these trusts, as we've been interacting with the Ingonyama Trust for quite some time. And I think it's important to note the recommendations. I think I'm comfortable with the recommendations as stipulated at the end of the presentation. What it responds directly to what is key for us as per a problem that is in front of us. Yesterday I witnessed in the United States of America a security guard blocking the Portfolio Committee of Education to enter into an education department building. And parliamentarians tried to put pressure on the security, but the security wouldn't agree for them to enter the building, because the security has got instruction from wherever, but they blocked successfully. Those members spent plus or minus 4 hours standing in front of the door, security just holding the hand, telling them, you're not going to enter yet. But being parliamentarians or no parliamentarian, talking oversight or no oversight, what I'm saying to you, you're not going to enter this building. It's a public building. It's a similar situation. And I'm drawing parallels, that sometimes to be an oversight doesn't guarantee you all the rights that you must enjoy. I'm raising this thing because there are certain concepts here, and I could see that there are many judgments that have been passed over time since the establishment of the Ingonyama Trust, which by understanding is an outcome of a CODESA kind of processes, which is a political process then. Now, just to ask this clarity, Clause 3 under legal framework and Clause 20, read with Clause 20. Clause 3 talks of the act, the master, I'm not sure master of what, but Clause 20 also talks of the exemptions of the chairperson in relation to the ownership. Can you clarify the two clauses? Are they related? Or are they in contradiction? Or what is it? The two clauses, yeah. The second issue for me is The state and vis-a-vis the Ingonyama Trust. In terms of our constitution, all land belong to the state. In terms of the constitution, all land belong to the state. Now, we have got this peculiar situation that says the Ingonyama Trust land belong to Ingonyama. Now, can you clarify this relationship? Can you clarify this relationship? The third issue is in relation to the Zulu Nation. The word Zulu Nation covers the whole of the jurisdiction of KwaZulu-Natal. And my assumption is that the Ingonyama Trust is a portion of KwaZulu-Natal. I'm not sure. I'm trying to talk to the scope of the Ingonyama Trust, a portion of KwaZulu-Natal. I'm subject to correction on this one. When you say the Ingonyama Trust, the Ingonyama acts on behalf of the Zulu Nation, do you differentiate between beneficiaries of Ingonyama Trust and the Zulu Nation? I'm not sure whether you get what I'm trying to say here. Do you differentiate between beneficiaries? The last question linked to that is Ingonyama Trust, is Ingonyama a member of the trust or not? Is he a member of the trust or an ex officio of the trust? What is the status of Ingonyama? Because if he's a member of a trust, for me, the assumption is that he's also a beneficiary, constituting part of the beneficiaries of the trust. But if it's not, what is he's a member? Okay, that's a small question. Is Ingonyama Trust a member of the trust? Thanks, Chair, for now.
Well, thank you, Honorable Mkhaga. I noticed that our two honorable members, Honorable Matiase, wanted to add to what he had already asked, and also Honorable Nana. Is that correct? Okay. Honorable Matiase.
Thank you so much, Honorable Chair, once more for giving me opportunity to make a contribution. Honorable Chair, I don't know where in the presentation there is any inference that the land belongs to the king as suggested by honorable members of the DA. I don't know, we must direct us to any paragraph that's tried to suggest that. That being the case, Honorable Chair, page 2, paragraph 7, which Honorable Nana refers to as bullet points, reads as follows. Section 2, subsection 3 of the Trust Act stipulates that Ingonyama is a sole trustee of the trust. Not owner, but trustee, which shall be administered by the Ingonyama. I have a sense that this reference in this passage that I've quoted might be the reason why there's confusion from members of the DA. But having noted that, Honorable Chair, can we read that in cross-reference with paragraph 10, paragraph 9 rather, on page 4. That sets out the parameters for the board with that extensive quotation, The board shall administer the affairs of the trust and the trust land, and without detracting from the generality of the aforegoing, the board may decide on or and implement any encumbrance and so forth and so on. So there seemed to be contradiction between paragraph or bullet point 7 and paragraph 9 with that extensive quotation. Secondly, Honorable Chair, notwithstanding Section 2A, subsection 3 of the KwaZulu-Natal Ingonyama Trust Act, which determines the composition of the board, as that can be referred to paragraph 10 or bullet point 10. Which says, the board shall consist of the Ingonyama or his or her nominee, who shall be the chairperson of the board. Unwritten convention or precedence since the enactment of this act and the subsequent amendment, the Ingonyama has been assigning a chairperson or his nominee to be the chair. And that serves as a precedence. I would want to understand to the legal office that would, as if the king was to get his way by dissolving the board and act as the chair of the board, would that not be in conflict with this precedent that has been established, or what I refer to as a unwritten convention? And what would be the legal and cultural traditional consequences if the king, the Ingonyama, was to present himself as the chair and have to appear before the committee as you recommend in page 11, paragraph 42 of your report? Thanks, Honorable Chair.
Thank you, Honorable Matthias. Honorable Nana.
Yeah, thanks, Chairman, once again. I'm sure our colleagues from Legal Services will realize that some of us are battling to wrap our heads around this thing. And it's pretty much because the majority of us in this committee are new, and the Ingonyama Trust issues are quite complex. Some of our colleagues are in a advantageous position because they've served in this committee before. So please do indulge with us. We're pretty much in uncharted waters, some of us. Secondly, and thanks for the correction, Honorable Matthias, it's not a bullet point, it's paragraph. You see, English is not my first language. In paragraph, I just forget the paragraph, but somewhere it says, because the Ingonyama Trust gets given public funds, it therefore has got to account in terms of the PMFA. I agree with that. But it is my understanding that besides the funds that the Ingonyama Trust receives from the public purse, they also do generate their own income. Is that income, in terms of the law, are they expected to account for the income that they derive? as an entity. Thank you.
Well, thank you. I hope our legal services actually did note all the questions that came through. I now am giving them the floor to respond. Thank you.
Oh, sorry. Thank you, Chairperson. Perhaps I should start by saying, as indicated by the other honorable member, that perhaps some of the questions should have been part of the brief that was sent to us, which then would have enabled us to do a thorough research around those issues, because we did not prepare for them because they were not part of our brief, but nonetheless we will try to respond to those that we can. Perhaps starting with the last question that relates to the obligation of the Ingonyama Trust Board to account. Yes, I think that honorable member was referring to paragraph 30. Oh, I'm reading a paragraph 33, but let me just check on paragraph 16. Yes, paragraph 16. Well, the question was whether because they are receiving public funds, that is the requirement for them, therefore, or that creates an obligation on the trust to account. Now, the question arises in the event that they are raising their own funds, will that still be obliging them to account? Perhaps, Chair, I should point to paragraph 33, which states that the board is a public entity as contemplated in Schedule 3 of the PFMA. And therefore, that creates an obligation on the board to account because it is an organ of state, it is a public entity. So it's not just a question of them receiving public funds, but by virtue of them being a public entity, they are accountable in terms of the PFMA Act.
That is whether those funds are generated, they are self-generated
Yes.
through their operations.
Yes.
Okay.
The first question that we noted was regarding if there will be a vacuum in the operations of the board. I will understand that is if the board becomes dysfunctional for one reason or another. Maybe that's my understanding of the question. Look, Chair, as I've already indicated, that is not the question that was given to us in our brief. But I will understand that it is the minister that has the oversight responsibility into the running of the affairs of the trust that needs to attend to that, to see to it that the board is actually functioning in accordance to its mandate flowing from the legislation. Another question that was posed was if this is the new dispute or it has been there. Well, Chairperson, I think that is a factual question. I don't think it's a question of law. But I do understand that the late King Goodwill Zwelithini KaBheka Zulu, while he was in terms of the legislation, the chairperson of the Ingonyama Trust Board, but he always nominated somebody to serve in that capacity. I'm not sure if there was a similar dispute in the past. perhaps maybe somebody can assist with that particular fact. I'm not aware of that. Now, another question was relating to the ownership of the trust. The honorable member said it is understood that the land belongs to the king. And how is this now coming to be construed as if it's the beneficiaries that are owning the land? Mr. Chairperson, I referred to a specific judgment where this was determined that the king actually is the trustee who is acting on behalf of the communities or tribes that are identified in Section 2, Subsection 2 of the Trust Act. There are various communities that are listed under that section, because I believe there was another question similar to that that was asking, given the fact that KZN is vast, that is KwaZulu-Natal is such a vast area, does the Ingonyama Trust hold all the land in KwaZulu-Natal? Well, in my understanding, Chairperson, it's when the trust was created in 1994, the land that fell into the trust was all the land that formerly belonged to the former KwaZulu-Natal self-governing state. It's not necessarily the entire province, if my understanding is correct of the legislation. The question relating to the consultative process that is followed when the minister appoints the members of the board. The question was, what could have been the rationale behind that process? Because this section stipulates that the minister consults with the premier for the appointment of 4 members of the board, and also in consultation with the premier, who shall consult with the Ingonyama and the chairperson of the House of Traditional Leaders. My understanding of this provision, Chairperson, in the Trust Act, which is Section 2, capital letter A3, is that while the minister has these powers to appoint the members of the board, such powers has to be exercised cautiously. In other words, there must be a consultation process before the minister can appoint the members of the board. Well, short of speculation, Chairperson, I would imagine that the intention of the legislature was to ensure that the process in appointing the members of the board does not get to a point where the minister can unilaterally impose members of the board without due consultation. In fact, if you were to read in paragraph C of that section 2A3, it says 4 members appointed by the minister with due regard to regional interest in consultation with the premier, who shall consult with the Ingonyama and the chairperson of the house. I will say, Chairperson, this would have been to safeguard the process against any unilateral action by the minister. Oh, sorry, my questions are written in shorthand, so I'm battling to read my own handwriting at times. Well, the question that also arose was that it is understood that the Amazulu king is the owner of the land. Now the question is, how is it possible that the committee holds the chairperson accountable for the affairs of the board, if I understood the question correctly. Honorable Chairperson, it is a fact that it's the chairperson or the board that accounts to the House by virtue of the fact that the entity that is the accounting authority, which in this instance is the board, is a public entity for the purposes of Section 49 of the PFMA, which is because they are this institute. I mean, this entity is listed as a Schedule 3 entity, which therefore means the chairperson in this instance, unfortunately, the chairperson is the king, but in terms of the legislation, the board, I mean, rather the Ingonyama Trust Board, is accountable by virtue of the fact that it is a public entity as contemplated in the PFMA Act.
I'm sorry to disturb them. I thought the members were actually, I'm trying to understand the context of the question of the members to say that from where I'm seated, I think the members wanted some clarity on the issue of ownership. You know, of the king and also the beneficiaries. So where does the ownership lie? You know.
I'll tell you why I'm asking this question. Some of my colleagues will argue that the king is the owner of the land of the Zulu nation. I mean, it's been said in our committee many times, you know.
Including by Matthias.
You know, so some of these questions, honorable members, we ask them because we want clarity. You know, lots of things are being said, as I said, and yeah, I mean, it would be very helpful. And I think, Chair, the fact that we are sticking to it is going to clear quite a lot of it. It's a pity that not all of us are in this meeting.
I did not hear what Honorable Matikizela said.
Can I repeat
Can I
it,
say
Chair?
that again?
Okay.
I didn't hear what
No, Chair, I think Honorable Member Matthias accused us of being confused. We are not confused when we are raising this matter. I thought I should give that clarity. If you go to any kingdom or any chieftaincy in South Africa, they will tell you that they own the land. And in fact, I recall the EFF and the MK saying the same thing in this committee. You see, I was raising this issue, Chair, because I wanted to get to another point, but for the sake of progress, I will stop, because this whole issue emanates from the challenge of security of tenure in rural land in South Africa. That is why Clara was thrown out. That is why the communal land tenure bill is still stuck in the department, because as long as that is not resolved, we will always have these problems. I think that is where I was going to. So let me stop here for now.
Okay, Honorable Matthias.
Well, the honourable members must admit to their own ignorance of the law and not blame their ignorance on us. That's the first point. The second point is, at no point the EFF ever said the land belongs to the king. It's common sense that nowhere else, even in pre-colonial arrangement, before 1652, has ever been an understanding among the African people that the land belongs to chiefs or kings. Even at that very primitive stage, there's been a common understanding amongst our people that the land belongs to the people, their kings and chiefs are the custodians of land. The EFF view has always been consistent, Honorable Chair. I think I need to spend 1 or 2 minutes in that it may seem that because of the intricacies of acquiring and getting land in the hands of our people, find mechanisms of getting land away from the colonial settlers into the hands of the people. And the challenges that goes with the amendment of Section 25. It may seem that the manner in which the Zulu people acquired land through the Ingonyama Trust Act could have been a mechanism considered then to acquire land, place it in the people's hands, and deal with the contradictions of how do we democratize ownership away from feudal forms of ownership. That's the view that we have expressed in this meeting. Given in the hindsight, the challenge that we confront with to take land away from the colonial settlers. But we maintain that land must be collectively owned by the people and have institutions such as the state to serve as the custodianship of land ownership. So that confusion must not be blamed on us. They must blame it on themselves. Thanks, Honorable Chair. Can we now allow the Honorable gentleman to continue his presentation?
Honorable members, I am now going to be loath to allow members to actually, disturb the flow of the response, because now there is a big temptation of actually. Yeah, there will always be the second round. Let's give it. Okay.
But thank you, Chairperson.
We are dealing with a very complex matter, and there will always be sometimes contradictions and confusions and concerns, but we need to deal with it. That's the reason why we actually asked for the legal opinion, so that we actually move from an informed legal position going forward. Thank you.
Okay. Thank you, Chairperson. Perhaps I should start with this question relating to the ownership. If I may just refer the honorable members to paragraph 23 of the opinion, which quotes section 2, subsection 5 of the Trust Act, which provides that the Ingonyama shall not encumber, pledge, lease, alienate, or otherwise dispose of any of the said land or any interest or real right in the land, unless he has obtained prior consent of the traditional authority or community authority consent, close quote. Chairperson, the significance of this quotation in this section, it gives us an insight into what rights the Ingonyama has in respect of the trust-held land. From reading this, it will appear as if the Ingonyama may not do anything in respect of that land. For instance, all those transactions, if you were, that will normally flow from ownership of property. But in this particular one, it says, for the Ingonyama to do any of those transactions, meaning to lease the land or alienate the land, that is to sell the land, he may only do so if the Ingonyama has obtained a prior written consent of the traditional community authority or community authority consent. This is further reinforced in the Kasak judgment that I referred to earlier in the next paragraph, where the judge stated that the true and beneficial owners under Zulu customary law of trust held are actually those tribes or communities as listed in section, as referred to in section 2, subsection 2 of the Trust Act. Our understanding of this, particular section of the Trust Act, read in reference to the CASAC judgment, it places those tribes and communities as the true and beneficial owners of the trust held land. That is what is provided in this particular Trust Act. I think this also partly answers the question that was raised earlier, that how do you determine who the beneficiaries of the Ingonyama Trust held land, given the fact that the Ingonyama Trust spans over the KZN area. I think I've already indicated that when it was formed in 1994, all the land that belonged to the former KwaZulu-Natal self-governing state was then transferred to the Ingonyama Trust, meaning that not all of that area belonged to the Ingonyama Trust. Now, to the second question is, how do you determine? In terms of the legislation, it's stated there. In fact, when you go to the annexure of the Act, it will tell you exactly the list of the communities. All the tribes are listed in that schedule. Those are the communities as contemplated in section 2, subsection 2 of the Trust Act, are listed in the schedule of that Act. There was another question relating to the exemption of a trustee from furnishing security. That is, it emanates from provisions of Clause 3 of the legal opinion. This was purely to distinguish the Ingonyama Trust from other ordinary trusts, because in terms of the Trust Property Act, which regulates all other trusts, it specifies that a trustee shall be obliged to furnish security to the satisfaction of the Master of the High Court. It's the Master of the High Court that must be satisfied that the security that has been furnished by the trustee is satisfactory before the trustee can commence with his or her duties or perform his duties as a trustee. But the only difference is that now with Ingonyama Trust Act, the trustee, that is the Ingonyama or Isilo, is exempt from furnishing such security as required in terms of the Trust Property Act. Another question was, what will be the legal implication if the Ingonyama were to dissolve the board? If I still remember that question. Honorable Chair, I think I have partly answered that question in my presentation, albeit my reference was to the removal of a single member of the board. I think I stated that the power to appoint members of the board is with the minister after following the due consultative processes as laid out in the Act. So Similarly, it will be the minister that will have such a power to dissolve because he appointed the board. Therefore, any dissolution by another person other than the minister will be unlawful.
Chairperson, I think it's appropriate for Honorable Madikizela to probably crystallize the question asked, because I don't think the legal advisor got it.
No, I know the legal implications. Maybe you didn't hear me correctly. I was talking about the
Speak to the mic.
I was talking about the practical implementation of that of the consequences of that. I mean, let's say, of course, I mean, you go to court and say we challenge the trustee or the chairperson by removing the board. I was merely talking about. I know you're talking about legalities, which I respect, but I was talking about the practical implementation of that judgment, if you will. So how do you do it? Because the trustee or the chairperson enjoys the support of the beneficiaries, whether his decision is legal or illegal. How to implement that decision in a situation like that? Because obviously, it's going to be difficult to force the trustee and the beneficiary to accept the board that they have no confidence on. So I was just merely talking about the practicalities of that. I understand that you might not be able to.
Yeah, in fact, what the Honorable Madikizela is asking is very important because, you know, out there, if you go to those tribes and beneficiaries and ask them a simple question, who owns the land? They are not going to tell you that this is our land. Their first response is that umhlaba wesilo. And then they will go on and say, Koda futhi ngowami. Why say it's mine? It's because he has the exclusive right to actually, unlimited right to actually use it as he or she pleases. I am the subject of the king. But that's the practical example. I actually reside on a piece of land my forefathers actually had owned. Nobody has a right to take that from me. But if you ask me who owns this land, I will tell you this is the king's land. That is why if I decide to move away and go and live in Oranje, for instance, I'm obliged to go to the king and tell him that, Your Majesty, I'm now leaving. I'm now going to actually relocating elsewhere. So why I'm reporting? I'm actually reporting because this piece of land, I'm actually in a way saying to him, I am handing over back this piece of land to you so that you are free to actually give it to someone else. You know. If he decides not to give it to someone else, he will tell me, but you have children. You who might want to come back and actually continue to live on this piece of land. And for that reason, I'm not going to give it to anyone else. It's going to remain empty. So that if one of your children actually decides to come back, he must actually find his or her forefather's piece of land intact. So that is where the intricate, meaning of ownership lies. Because we are here talking about the ownership as defined by the law. But there is socio-cultural issue, the definition of land ownership as Africans. Emakosini are out there. Amakosi, they perfectly understand that they're holding the land in trust for the people. They know that. But also, the ordinary people, they know that they are actually residing on the land which is being held in trust for them. And therefore, they are not free to do whatever they like with this land. If you decide to go to recycle in the Eastern Cape, yes, you can't take this land. You can't sell it. You can't sell it because it's for the people here. You can't sell it. So that is the reason why you find a lot of, concern about the state of Itala Bank right now. Because the commercial banks, your Standard Bank, your ABSAs, are actually not giving loans to the people to build their houses on this communal land ownership system. It's only Itala out there to the poor people who actually is able to give loans to those people. So that is why you find so much concern from the people in the rural areas about what is happening within Itala. It stems from the system of land ownership. Ownership in our situation is not defined by a piece of paper. No. If my forefather was involved in Isandlwane in defense of this land, for me, for generations to come, including me. So that is why I would always say I claim ownership of the land there, but under the custodianship of the king. Because I am the subject of the king. Obviously, the king can't be the king cannot have a kingdom without land, because kingdom is defined both in terms of people and land. You can't be a king in a vacuum. Thank you. Did I add more confusion? Well, there is a hand from Honorable Bosso.
Chair, thank you. I just want to confirm this. What you actually explained now is that the king causes it to be impossible to break the line or to break the chain, because you might not like to be on the land, but your children or your grandchildren might be inclined to that again. And in a private ownership with title deeds, if I'm not interested and I sell the land, I broke the chain, and my children and grandchildren can't do anything about it. It's gone. But what you explain is that the king gives that continuity to not breaking the chain of the ties to the land. Is it correct summary?
Yes, he safeguards that, because as things are right now, there is now suddenly a migration of people back to their original, communities, away from the urban areas. Why? Some municipalities are doing well. There is now electricity in rural areas. There is now water supply. Roads are now being maintained. So the question is, why should I actually be living in cities and pay rates when my forefather actually has a piece of land in a rural area which is there, sitting there waiting for me to claim back freely, without paying a cent?
But another implication, Chair, is that you are poor with this asset, because without the security of tenure, you can't trade with it to improve your economic situation for you and your generations. And that is why, I was waiting for the presenter to finish, that even in that, paragraph 23 and 24, where you are arguing that, arguing the ownership, I mean, those people don't own that land either. Because, I mean, without the security of tenure, which proves that they own it, they don't. And which is part of the reason, Chair, Itala is bankrupt, because it's funding dead assets. Because, I mean, if you don't have a security of tenure on that asset, which means it has no value. And that is why I've been arguing that the influence of the traditional leadership does not stop just because people are empowered, just because people have title deeds and they own their assets and they can be able to put meaning into it in terms of economic value. So I think it's a debate, this is a debate that we should have going forward, because as I said, most of the bills and the acts that wants to correct this injustice of people in traditional, setting, having these vast tracts of land that have no value. I'm one of them. I mean, ekhaya eMbizana, ndakhe umzi omkhulu, but I have a PTO, which is permission to occupy. If I were to take that house and bring it to a suburban setting, it will cost millions. And that is what is trapping us in poverty, as the majority of black people who are living in rural setting. Thank you, Chair.
Well, thank you, honorable members. I wish we would find time to debate this at some other time. But can we allow the legal services to conclude their presentation so that I can allow the second bite? Yeah.
Okay, thank you, Chairperson. I was just about to touch on the very same issue which pertains to this contentious ownership of the land. Perhaps in doing so, if I may just touch briefly on the merits of the CASAC judgment, which pertains to the PTOs that the honourable member just referred to. In this case, the issue was that sometime around 2007, the Ingonyama Trust and the board decided not to issue PTOs anymore, that is the permissions to occupy, and then instead they converted the existing PTOs to lease agreements with those communities and tribes that are residing in the trust held land as defined in section 2, subsection 2 of the Trust Act. Then the matter was taken up to court to review that decision. And the court ruled in favor of those communities that in fact those lists that they concluded were invalid and unlawful, and therefore they were all set aside. In addition to that, the court ordered that those people must be reimbursed for all the monies that they paid pursuant to those lease agreements that were subsequently declared unlawful and invalid. So Chairperson, it's a very tricky one, because here we have the legislation that says, well, the Ingonyama cannot do anything concerning this land that is held in trust without getting the consent of the people, the written consent of the people. Meaning that even if the land belongs to the Ingonyama, as most people are arguing, but it will appear as if he is also restricted in terms of what he or he cannot do in respect of that land. And now the judgment in this particular matter reinforces that legal position, that they are the true and beneficial owners. Hence, the court ruled in their favor that they shouldn't be paying lease in respect of that land because they are the true and beneficial owners. Thank you, Chair.
Honorable members, there are, I will allow just 5 more minutes for follow-up questions. Honorable Mahaka, did you have your hand up? Yeah.
So sorry, Honorable.
Oh.
If you may just remind the question, I may have missed it.
Is King ex officio a trust? You answered that.
Oh, okay. Ndibe nalena ndithetha ngokukaNtu wami.
What if I remember was actually even asking the status of, or the Zulu Nation versus beneficiaries.
Yes.
Whether these two are one.
Yeah.
And also the status of the king
Yeah.
vis-a-vis the beneficiaries,
Yes.
whether he himself is part of the beneficiaries.
Okay, thank you, Honorable Chairperson. I must apologize. It was not my intention to ignore the question. I possibly just forgot to note it. Well, in terms of the legislation, I think that I've referred to the position of the king. He is the trustee that is acting on behalf of the beneficiaries. In terms of this Trust Act, the trustees, the trust beneficiaries are listed in terms of Section 2, subsection 2 of the Trust Act. It's the communities that are listed in the schedule that are the trust beneficiaries. The king is only acting as a trustee on behalf of those communities. Not a beneficiary, is a trustee on behalf of the communities that are listed in Schedule 2, subsection 2.
I'm not sure whether the king obviously lives within a community, which in terms of the law is actually a beneficiary. So he's a member of that community. And by extension, he is a beneficiary. Is he a beneficiary?
Well, Chairperson, if he resides in those communities that are listed, by all means, he is a beneficiary because there is no specific provision in the Act that excludes him from being the beneficiary if he resides in those communities that are listed.
Okay. Yeah. Because besides being the king of all other tribes, he has his own specific tribe called Usud. He is the Inkosi of Usud. He delegated his powers he appointed someone to act on his behalf as Inkosi of that Usud. But if you talk about issues relating to that specific tribe, he is actually involved, besides being also the king of the entire the Zulu nation, and also the king over all other tribes. But he has his own specific tribe where he comes from.
Thank you, Chairperson, for that insight. Thank you very much.
Uzonginikela ke Chair.
Yeah.
Hey, it's very complex, Chair. It's worse if you really study the African cultures and traditions. It's very contentious. When it goes deep to the heart exactly of what we're supposed to be doing. Africans reclaiming their land back to their own ancestors. Because, Chair, if there were forced removals, Africans were removed from their own land, and you are saying there will always be an attachment to the land of your ancestors in terms of our traditions and cultures. Even if Van der Merwe comes tomorrow, came centuries ago, remove this family, our people will always point where their forefathers were, and exactly, and that cannot be bought. There is no compensation, amount of compensation that can address that particular question. It goes to that heart, the heart of the problem. And I'm agreeing with you that maybe at one stage we need to engage on this particular serious question around it. Because I'm trying to relate Orania with Ingonyama Trust. Because both of them are a product of a Codesa settlement in 1994. But definitely, you're not talking trust when it comes to Orania. You're talking a different approach that was reached politically around those particular issues. But it does not nullify the question that that land also is part of the South African land, as managed by the South African state. State acting on behalf of the South African people across the board. Now, I'm trying to relate that, Chair. I might be creating some more confusion, but let me stop there, Chair. It was just my comment, and I know that comment might provoke some individuals here. Well, because I thought that Trump made this thing easy. He invited some particular question to go to America so that we're able to address this problem.
In fact, what you
If
are,
really-
what
if-
you are already saying has provoked. It
Well,
has the
if-
potential.
If that executive order would be honored, things would be easy for this committee to address. It would be easy, Chair, to address. No, Chair. It's a matter that I was raising just in passing, because I know that we must discuss this question of expropriation in context, act as this committee, so that we understand, so that we don't listen to media, etc., to understand this particular issue. There's somewhere where you're talking review process. I'm not sure. I've been perusing this document. I'm trying to check this review process. I'm not sure which clause. But my short question was in relation to if it happens that some trustees have sold land without the knowledge of the king, and now the king is intervening to stop that kind, but that's corruption, to stop that. Now, and surely that would constitute a dispute. And if you want to unravel a dispute, you must undergo a legal process, which constitutes a review process. Who then takes this responsibility between the minister and Isilo of undertaking this review process? Is it the king or the minister who's got this responsibility to undertake this particular process? And where and how long does it take? Thanks, Chair.
Honorable Matthias, did you indicate?
This 5 minutes. Is it on follow-up questions or is it on the way forward?
I thought you would have some follow-up questions or the second bite to the cherry.
Okay, I guess that it would be.
Then we will have a way forward. Yeah.
There's a question I asked specifically on an unwritten convention, which I refer to as precedents. In the event that the Q dissolve the board, or for argument's sake, the minister chairpersonship of the board, what are the traditional customary law implications? And legal implications broadly, should the king come and appear before the portfolio committee? And we have to ask questions and to hold the board accountable, and in that case, directly having to ask to hold the king accountable. What would be the implications of that? That's the question that I asked earlier.
Well, over to the legal services.
Thank you, Chairperson. If I may start with that question that was raised concerning where a trustee sold a land without the permission of the board or the chairperson of the board. Well, in that instance, who should proceed with the legal proceedings? Perhaps if I may just refer, the honorable member was looking for the specific section in the legal opinion. I think that is from section 37, sorry, paragraph 37 of the opinion. It deals with the legal recourse and the oversight mechanism. Now, to the question, perhaps let me start by saying the Ingonyama is the sole trustee of the trust, so there is no other trustee. Perhaps maybe I should, for the purposes of answering the question, that it could have been a member of the board, not necessarily a trustee, hypothetically speaking, that sold the land without the permission of the board, no, of the trust. Well, as I indicated earlier, that the trust is able to institute legal proceedings. If I may just refer to the very same section, if you can just bear with me. Yeah, that's paragraph 5 of the opinion. It says, the Ingonyama Trust was established in terms of the then KwaZulu-Natal Ingonyama Trust Act. In terms of Section 2(1) of the Trust Act, the Ingonyama Trust is established as a corporate body with perpetual succession and power to sue and be sued, and to do all such acts and things as bodies corporate may lawfully do. Now, coming back to the question as to whether the trust can institute legal proceedings to review and set aside that transaction which that particular member of the board will have concluded in respect of the trust held land. The answer is that yes, the trust is entitled to pursue legal proceedings against that particular member of the board that will have alienated the land that is held in trust. The second question, I must also apologize to you, sir. I did not mean to evade your question, so to speak. I thought I may have answered it, but not necessarily in whole. The question is if the minister appoints the board as per the legislation, but the king is not keen to work with that board or is not satisfied, and he assumes the role of being the chair for the board. And now the question is, what will be the cultural implication of the king appearing before the parliamentary committee. Am I summarizing the question correctly? Okay, thank you. Chairperson, I think that I've stated in terms of the legal framework the accountability that flows from the legislation, that is the board being the accounting authority as a public entity that is required to report on its or account about its affairs. In this particular case, the cultural consideration, I will be honest, I did not investigate the practicalities of such. I only considered the legal framework within which the board is accountable for its affairs. However, having said that, in terms of the legislation, the king has a discretion to serve as a chairperson or nominate somebody that can fulfill that role as the chairperson of the board. As we all recall that in the previous, with the previous king, that the late King Goodwill Zwelithini Kabheka Zulu, he appointed somebody to serve as the chairperson, meaning that that would have been the person that will account to the committee when the need arises to do that. Well, he has a discretion to nominate somebody to serve as a chairperson. That essentially will be the person that can account on behalf of the board.
But then the rules here are saying for the committee, has got a right of inviting anyone
Yes.
before it's said. For anyone. It does not
Differentiate, yes.
You know, it's anyone. That's the relevance of this question for
Yes.
deliberation.
Yes, Chairperson, that is actually correct. That is what that section, and I think it's Rule 167 of the NA rules, read with section, I think 56 of the of the 55 of the Constitution, that relates to the accountability and the oversight over the organs of the state. Now the question is whether the committee may summon the king to come and account. I think, Chairperson, the law is clear in relation to that. Then the committee will have to make a decision on that, whether how they're gonna navigate that. But in terms of the law, the committee is empowered to do so, to summon anyone. But perhaps I should qualify this. I stated that the first, when you've exhausted means to get the person to come and account, you wouldn't issue a summon for the person to come without having first invited the person to account, and then if the person refuses, only in such extreme that then the committee may resort to that. But in terms of the legislation, the committee has those powers.
I don't know if Chair will allow me for a follow-up. Paragraph 10.
Okay, do you want to?
Composition of the board. And confers powers to the king.
Are you using your mic?
Oh, sorry.
Because the recording will not actually work if the mic is not on.
To use his discretion to appoint a nominee who shall be the chairperson of the board, or to have himself as the chair of the board?
Yes.
So my question is, in the event that he chooses to be the chair of the board himself and has got to appear before the committee, what are the legal, cultural implications? Because given the nature of the work of Parliament and through its committees, we'll have to ask questions which may not be comfortable to the king. So I want to understand, but you have partly answered. You said in your mandate and the brief you were given by the committee,
Yes.
you did not stretch your investigation to cover the implications of such a situation.
Yes.
So it will be one of the things that under way forward, Honourable Chair, we'll have to apply our minds as to what should happen from the point of view of the committee. Thanks.
Well, thank you. There was a question asked about Ingonyama Holding. I'm not sure whether.
There are interest here on that question that was posed by one of the honorable members here. It was under clause 22. I'm not sure whether it's relevant. He is not allowed to make a secret profit at the other expense or place himself. I'm reminded of these holdings sitting in Sentin, but managing the affairs, financial affairs of the trust. Accumulating profit in secret away from the board. I was just trying to check the relevance of that, and I'm not sure. I'm sure the member may not be, because we didn't raise that as a key issue. But I was interested also to that in relation to this clause.
Is the question actually looking at the issue of accountability and the oversight?
It's a judgment of Robinson and Renfontaine Estate Gold Mining. Not sure whether it's talking to, that's a judgment.
Well, thank you, Chairperson. Perhaps I should put the paragraph 22 into its proper context. This judgment, or rather this case, it serves to demonstrate the fiduciary relationship between the trustees and the trust beneficiaries. It was just intended to clarify that the person that is nominated or appointed to serve as a trustee, this is what is expected in terms of this fiduciary duty, as also entrenched in section 2, subsection 2 of the Trust Act. Now, coming to the question relating to the Ingonyama holdings, Honorable Chairperson, I will be honest, this is the first time I hear about it. In our brief, we did not get any request relating to the Ingonyama holdings, which we will have investigated how it fits into the equation. But from what I hear from honorable members is that the Ingonyama holdings is the subsidiary of the board. Well, Chairperson, we did not investigate. We were not aware of the existence of such an entity. But I just want to clarify that it does not relate to this paragraph 22, because this one speaks to the fiduciary duties of the trustee, who in this particular instance is the Ingonyama or Isilo, not the board, because the board is not the trustee, but is the Isilo that serves as a trustee. So this does not relate to the functions. It's only space to the relationship between the trustee and the trust beneficiaries. Chairperson,
Sorry, no, I didn't press, my daily balance. I'm asking Chair, just a follow-up, a small follow-up, sorry, on with it. How do you separate the chairperson of the board or a CEO? But I don't want to talk to persons here. The chairperson of the board from this clause, whilst he was part of the endorsement and the appointment and endorsement of this subsidiary. Was then, that was the decision of the board to establish a subsidiary. How do you separate it from this clause?
Maybe before he responds, maybe it will assist for us to clarify how this thing was actually, this entity was established. Yes, it was established as a business arm of the board. But what actually happened, the chairperson of the board that had established this entity then also became the director of this entity. So, and that actually conflated the whole situation, because then now the entity which actually has to report to the board and the chairperson of the board, it is now the same chairperson of the board that also is leading this entity. So now he was chairman of the accounting authority, but also leading the entity that ought to be reporting to the board. And then there was this stalemate: who reports to who is who in the zoo, because he's the chairperson of this board, but also the leader of this entity that ought to be reporting to the board. That's where the problem actually lies. And now with the new board now wants the entity to report. Now the entity is refusing to report. Hence, there are now two court cases, that two matters that are in court now, because the board had advanced some money to the holding to actually, as seed funding to start, their business. Now the current board, the new board, wants actually to do oversight on the Ingonyama holding, on the basis that it was actually given, seed funding. It was a loan. They want that loan paid back. Now these people here actually are now saying, no, you can go and jump. No, they don't feel, they don't want to accept that they are legally bound to actually report back to the board or pay back the loan. So hence the board has decided to take a legal route, to take the matter to court.
Currently, they are accumulating profits secretly outside the framework of the Ingonyama Trust Board. Is that correct? Well, I'm trying to make it accounting.
No, you are correct in the sense that they are not accounting. They have now become law unto themselves. They are not accounting to the body that created them, for a specific purpose.
Chairman,
Honorable Nana.
to the advocate's defense, he did declare upfront that he wasn't aware of the entity, and he actually didn't do some research on it. I think let's pack it and probably through our content advisor, I mean, we can try and get some more information, just to be fair to him. Thanks.
I would agree with that we actually pack that matter of the Ingonyama holding, because it forms part of the broader responsibility of the minister as an executive authority over whom we have oversight to actually tell us exactly what's going on here. You know. So, thank you. Now we want to hear members actually looking at how then do we move forward. We now have the legal opinion for which we are so grateful to the Parliamentary Legal Services to have untangled these legal, intricacies around the operation, the establishment and the operation of the Ingonyama Trust. So now we are armed with the legal information. So then how then do we move forward? I would like to recognize the hand of Honorable Matigizela and then Honorable Matthias.
No, Chair, I would like to suggest that this be part of the discussion when we discuss our program. Maybe we can allow the presenter to leave, because I think that's our discussion now, to say how do we move forward. I suggest that we make it part of our discussion regarding the program.
Well, thank you very much, Legal Services, for your kind assistance to this. It's indeed not an easy matter, as you have heard. We will actually rely on you from time to time if we come across some legal, lacunas, as it were. Then we will actually lean on you for legal advice. But as I said, this was the opinion from the Legal Services of Parliament, interpreting the law for us, and they making some conclusions. So this has empowered us as a committee to actually have have a lot of information, have enough information to actually deal with the issues surrounding the Ingonyama Trust. As members will recall, and I hope we are also going to be able to discuss our planned oversight to KwaZulu-Natal. This is part of our preparations to actually visit KwaZulu-Natal, and also it broadens our, our scope and our understanding of the nature of issues and challenges that actually are bogging down the operations of Ingonyama Trust. I was wondering whether the legal services could actually join us to the KwaZulu-Natal oversight visit. Please take this as an invitation, because we don't want when we get there, they start asking us about the opinions of the legal opinions of Parliamentary Legal Services, with you not being there to actually defend yourself. Well, thank you. I'm not expecting a response now. Thank you. Thank you. Honourable members, you are free to leave. Can we have 5 minutes comfort break?
Whenever I do the tickets, I'm serious all the time. I'm like, I have to check. I'm just a serious.
Congratulations. So you elected in all the structures. It's the next deputy president.
I should have been the deputy president. There's no one outside.
It was institutional. He came and left.
Of course, yes, traces his activity from the
No, I forgot my permit.
Can we reconvene, honorable members? Honorable members, a copy of our draft program for oversight visit to KwaZulu-Natal was circulated to honorable members. I wonder if we could actually have a look at that, because honorable members will recall that when we engaged with the House Chair, he actually said that he advised that we actually undertake our oversight visit immediately after SONA. So we had actually thought that we could actually undertake that during the last week of February, which will be from the 23rd, Sunday the 23rd to Friday the 28th. So I will actually ask the acting committee secretary to actually present that to us, and then members will be able to make amendments or additions to the program. Thank you.
Thank you, Chair. The draft program for the oversight is as follows. The committee will travel on the 23rd of February, which is on a Sunday, travel day. We will all be flying from various points to Umhlanga in KZN, Durban. And we'll be sleeping in Umhlanga on arrival. Umhlanga is, I think it's in Durban, yes, on the 23rd of February. So on Sunday, we're sleeping in Umhlanga. And Monday, we set it aside for audience with the Ingonyama, if that will be possible. But it's subjected to change because we are still waiting for the, after submission of the letter to the King, obviously we'll hear from him when he will be available to meet the committee. But according to this program, it's going to be on Monday the 24th. And then on Tuesday, we'll be having a stakeholder meetings. We meeting with the MEC on Cooperative Governance and Traditional Affairs, which is COPTA, and the KZN Provincial House of Traditional Leaders. And then after lunch, we'll be meeting the Ingonyama Trust Board. That will be Tuesday on the 25th of February. We don't have the venues as yet. We are still waiting for the confirmation from the guys from the department in KZN. And then on Wednesday, the 26th February, we'll be in Makatini to meet Makatini Scheme, FPSU. We'll have briefings also by the departments, Provincial Department of Agriculture, Provincial Office and the Department of Land Reform and Rural Development, and the briefing by Makatini Farmers, Structures and Organizations. And then after the briefings, we'll go to the site visit. We're going to visit the FPSU, the fields, orchards, and infrastructure development. On Thursday, the 27th of February, we'll be visiting the CPAs, Ubizo CPA, which is in Mpangeni at Kinkachwayo District Municipality. It's apparently 2 hours from at Jozini. And then after that, we're visiting the Zwelabantu CPA, Kwatuguza, in Elembe District Municipality. It's about 2 hours from Mpangeni. And on Friday, if possible, we'll have a debrief in the morning, depending on the flights, that especially for the members that are connecting in Joburg. If there is a chance, we will have the debrief before that, but that will be decided as the week goes by when we are in Durban. Thank you, members.
To honorable members. So this is a draft program. It has actually been, we have made the necessary applications to the office of the House Chairperson, and it has actually been approved. So it is now on the desk of the Chief Whip. Oh, and the Chief Whip also has approved it, I'm told, last night. So we need then to begin to roll out the logistical arrangements, because now it's now been cleared with all the relevant offices. We now need to immediately, as early as today, begin to again write to the King and ask for the audience. Because last time we had to do it because they were taking long to give us permission. You know, they were taking very, very long. There are certain things that need to actually meet specific time frames. Now we did that, and it's now water under the bridge. So we are now going to kickstart those logistics to meet with all these relevant people, ask them to actually, give us space to be able to meet with them. We thought that it would be wise to meet with the provincial MEC for cooperative governance and traditional affairs, especially because Amakosi are located in that particular department, because as beneficiaries we would also like to meet with them. So we can't meet without actually having, had an engagement with the MEC for cooperative governance and traditional affairs. And then we will then have the House of Traditional Leaders, as actually has been presented. Are there any comments from members? Honorable Matize.
No, Chair, I think I need to reiterate what we spoke about during our Zoom meeting. I welcome the program, and it's good, and obviously I note that it's subject to the availability of His Majesty, but I welcome it. I am aware that His Majesty will be delivering the State of the Province opening of Parliament on the 27th of February. I do want to reiterate what we said during the discussion, our Zoom meeting, about the intention of our visit, Chair. And given what we said during that discussion, I want to propose that we remove the Ingonyama Trust Board on this program. It's our entity. I mean, we can meet our entity anytime here, but for the sake of this visit, we don't want to muddy the waters. And of course, His Majesty believes, we know that we just received a legal opinion that says otherwise, But His Majesty believes, according to the legal opinion that he got from his own lawyers, that it is within his powers to remove the board. And given the objective of this committee, to really find a resolution that will bring His Majesty, who is the trustee, and the minister closer as this committee, I want to propose that we remove the meeting with the board until we hear from His Majesty the reasons behind. Because remember, we did say, we understand his position as far as the legalities is concerned as we receive this, the legal opinion. But I think it is my proposal, Chair, that let us remove the board and make a different time to meet the board as our entity. Thank you.
Okay, thank you, Honorable Matigizela. Honorable Lucas.
Thank you, Chair. I think it makes sense what Honorable Madikizela is saying, because I've been listening to the presentation, and they said, although they say that the trustee doesn't have the powers because it's vested in the minister, but they also said the remedy is that if this happens, the board must get legal recourse against to review that specific decision. That is exactly what is in that specific phrase, which means, according to my interpretation as a layperson, that the decision of the trustee is for now standing up until there is a legal review. I can be misinterpreting it, but I think that is what is exactly what stood there.
Yes, honorable members, it's maybe let us hear from Honorable Adams.
Thank you, Chairperson. Chairperson, the draft program is in front of us. I will propose that we discuss the program according to dates, according to the venues, and according to time. Why I'm saying this, that we was on oversight to KZN the last time, and we have experienced how long distance it is, how far it what the time of the meetings is. Sometimes we were on the road where we were supposed to start the meeting. So I saw there is time, Chairperson, and there is also traveling in. The secretary must explain to us the traveling time and the starting of the meeting time. Is it included, or the time that is allocated here on the draft program? Will it be the time when we start the meeting, or is it only the time for traveling? That is what I wanted to ask. Because if I saw on Monday, the traveling from Monday is to be continued. But Tuesday, is the traveling included in that 9 o'clock to 10? Or is it the time when the meeting will start? And so that means that if there is traveling, we have to travel at maybe 7 o'clock, from 7 o'clock to be on time to start the meeting. And every meeting has its own time, take its own time. So that, for me, that is important, how we structure our traveling time because of distance and the time when we will starting our meeting. Yeah, thank you, Chair.
Well, thank you, honorable members. Honorable Matthias.
seems to be. And on a Tuesday, we listen to the Ingonyama Trust Board. The spirit of our virtual meeting was that let's go there with a non-answer. So I know that we can at any given time call the Ingonyama Trust Board for us, but we'll be there to meet with all stakeholders. So I beg to differ with one of what you think that just last check. I don't know whether we've placed the cart before the horse by presenting the program without reflecting on the way forward, on the
Or what we have actually been given. Yeah.
I'll leave to guide.
Thank you. Thank you for actually reminding us. I'm sure it was falling within the cracks because we had that 5 minutes break, and yet it was very important. It is very important for us to formulate some kind of a way forward, because it might actually inform the kind of program that we would eventually come up with. Honorable members, we have heard the legal position as presented by the legal services of Parliament in relation to various issues, the legal questions that we had actually asked them, and we had asked them to help us, clarify, and indeed they have done so. So what is then our way forward? We have heard what they are saying. They've given answers to what we had asked them. Some of the answers may not go down well with us, but they are a reality because they are predicated on the current legal framework. I'm ready for the Mama, Honorable Mam Dalan.
So, as part of the way forward, I heard you extending the invitation to them. I don't know whether they have taken it seriously. Indeed, there must be part of us going there as a backup. If we agree, which means the chairperson must write, the committee must write a letter to them, officially invite them for the gym as part of the way forward. Thank you.
Thank you, Honorable Ndalane. Any other, Honorable Matthias?
Thanks so much, Honorable Chair. Honorable Chair, I've got 3 points here. The first one is, let's disabuse ourselves of the notion that any king, doesn't matter who the king is in a country, has absolute right of ownership over land. The concept of private ownership of land is foreign to African customary law, Honorable Chair, and that's the point we have made. We have explained it nicely for all to understand. That concept of private ownership is foreign to African customary law. We are likely to make mistakes if each time we have to deal with this form of or type of land ownership, we conflate customary law with common law. A mistake with our colleagues often makes when they make contribution. Let's not conflate common law with customary law in the understanding of the matter was seized with. Two, Honorable Chair, we need to make it patently clear that the King's decision to dissolve the board has no effect in law. That's the first point. And therefore, Honorable Chair, because it has got no effect in law, the board is lawfully in place, in office, until the minister dissolves it. And in exercising his options and discretion, the minister may consider the following options which I table here. The first option is for the minister to summarily dissolve the board or seek mediation between the king and the current board, or appoint an administrator should he decide to summarily dissolve the board, to fill in the vacuum that would have been left after the minister has dissolved the board. These are options that the minister has. Lastly, Honorable Chair, the committee must recommend to the minister to establish a ministerial panel of experts. A ministerial panel of experts to conduct research, investigation, and do a fact-finding on the functionality of the Ingonyama Trust Board in relation to its governance structures, governance systems, processes and regulations, and perhaps also reconsider and make recommendations if there is a need for Parliament to, if there is a need, and that I say cautiously, that if there is a need to amend the Ingonyama Trust Board Act, Trust Act, in the case KwaZulu-Natal Ingonyama Trust Act, if there is such a need, and if there is a need, such must be part of the recommendation made by the panel of experts which the committee must recommend to the minister to appoint, so that we systematically deal with all aspects of the fallout and the impacts as a result of the decision of the king, and also set in motion and in process a cogent and solid solution should matters of this nature arise again in the future. Thank you so much, Honorable Chair.
Thank you, Honorable Matthias. In fact, we will after the way forward that we are discussing, we will actually also be looking at our program. If you can actually look at our program for this quarter, on the 21st, we would be meeting with the minister, and also the discussing the issues around the Ingonyama Trust and Ingonyama Trust Board. So I think it would be befitting when we discuss this with the minister, we then actually present our views that you have actually articulated to the minister, and hear what he has to say. By the way, I mean, after the sitting there, he buttonholed me and saying that he has actually received a letter from the king agreeing to meet with him, because we remember when we had that Zoom meeting when he was on his way out to Germany, he actually indicated that he had written to the minister, to the king, and he had not responded then because he was under retreat somewhere. And then he has since responded and he has agreed to grant him appointment. It's just that the date has not actually been specified. So, but our program actually has a provision to meet with the minister to discuss, to actually get some feedback from him, because there were certain things that he was actually saying he was going to do. So we want him to report on the progress of those things in relation to the operations of Ingonyama and the developments in the Ingonyama Trust Board. So I would ask that we reserve those recommendations for that meeting with the minister. But there is no harm in brainstorming over those proposals presented by Honorable Matthias. Honorable Mahar.
No, thanks, Chair. No, Chair, in support of what honorable members are raising. I had a view that we are approaching this meeting with the King with open mind as a fact-finding mission. And that is why we're requesting many interaction with many stakeholders, because we want to understand exactly the chemistry around that environment. Now, I've considered the recommendations which are empowering us. Surely they will be our tools or instrument as we are engaging, because we're not going there to tell the king. We're going there for engagement. So that, because we understand that he's got his own legal team also. And therefore, our own position, being ready for such, becomes important. They may question even the legal advice that we have here through their own legal teams on the other side. So might be engaged in that. That's why I'm supportive of this invitation of this legal person. Although it seemingly was not sure, but I'm not sure it's operating on the basis of submissions. Because I thought when you are requesting the adjudication on matters of that nature, you are forced to study the whole environment, particularly if you are preparing for a portfolio committee. You don't deal with one sentence because we send you this submission and you exclude other elements. But understand the magnitude of work they are dealing with as far as that is concerned. The consultative process was interesting for me. You consult the premier, the king, and I take it that's a two-way traffic. Now, my worry here is that there's nowhere here in this program where we pay courtesy to the premier of the province, because it's part of this whole situation, because it's being consulted. You might be surprised if the king will tell you that, no, we consulted our beneficiaries, our premier, and we agreed on this approach. Now do we deal with that? Because the possibility is that they've consulted each other in the province. Hence, Majesty took this particular posture around this particular issue. And I'm saying, if there is possibility of finding, well, there's a 1 hour session with the premier so that he understands exactly where we come from in terms of our own approach as far as this is concerned. Now, I think, Chair, this question of investigation must cover the whole aspects of these disputes. I know that there are cases in court. Some matters might be sub judice. But this investment holding that is not cooperating with the board is a matter for me that must be taken into consideration as part of the investigation. So that if there's that defiance to that magnitude, also are able to intervene at that level. Because what is clear there, we've got money of the state that is not accountable for, not accounted for. Money of the board, the state, not accounted for. And we can't be folding our arms as far as that is concerned. I'm not sure of these court cases, how far are they in terms of being dealt with. Ingonyama Trust for me is a model that need to be studied properly. I'm raising this question, it might be a political question, but I'm raising this question because we don't have a model that is suitable for rural areas. We don't have that model. Hence, we're stuck with Spluma. When chiefs and kings were raising the issues of Spluma, there was a dispute between government and kings around the question of Spluma. And I'm saying it's a model that must be taken into consideration and study it properly and check whether this cannot assist us in terms of its expansion, if it's relevant for rural areas. But we don't have a model that I know of for rural areas in terms of economic development. But for me, this one seems to be focusing in that particular area, unless otherwise, Chair. So I was going to say that it's a model that must be taken into consideration. If we have to research it, we do so. If there's a research that has been done by Parliament, we consider that those outcomes, so that we study this, so that we don't necessarily punch holes on a model that could serve as a base of assisting us for the development of rural areas. Because currently, we don't have such a program, such a model for rural areas. Each province approaches it differently, depending to the king of that particular province. Standardize this particular program might depend on the question of our research work and our own studies as far as this particular matter is concerned. That's a matter for portfolio committee that we must consider, not for this meeting, but for ourselves as a portfolio committee, so that we're able to engage meaningfully when it comes to different, because we're going to confront many of these areas in these provinces coming from these kingdoms. I know of a kingdom, a dispute in one of the provinces, it's Northwest. This woman, Queen Judge, Limbombo, Queen Judge. It's a matter that has got its own in the Eastern Cape. The question of kingship is always a problem in the province. So I'm saying for us to be clear and for ourselves, I think that this model needs scrutiny and consideration. Thanks, sir.
Well, thank you so much, honorable members. Honorable Lucas, did you have your hand up? I can't remember.
No, Chairperson.
Oh, thank you.
Fine.
Well, I think we have actually done justice to this matter for now. As I said, on the 21st, we'll also be meeting with the minister on the very matter, and where he will actually be giving us some feedback on certain issues that he is currently attending to. So I would ask that we park the matter there, and appreciate that the Legal Services section of our Parliament has done a wonderful job. Indeed, we are much wiser now with their opinion and presentation which they made. So honorable members, we are running out of time. So is there in relation to our draft program, oversight program, is it a suggestion that we include the meeting of the Premier, with the Premier? And also that I didn't hear the decision of the members on the issue of meeting with Ingonyama Trust Board, because there are two suggestions. One suggestion is that we should actually cancel the meeting with the Ingonyama Trust Board, but also there is an opinion that we should continue to. There is no harm in meeting the Ingonyama Trust Board, because we would have had an audience with the King. So what what is the view of the committee? Yeah, Honorable Mkhaga.
Now, Chair, I want to persuade our colleagues. Because I've looked on the question of time, because I thought that would be the one that could inform us not to meet the board, the question of time constraint. I would persuade our colleagues that let's allow the program as it is. Because my interest also would be to understand their position and the posture throughout this pressure and turbulence that was happening between the King and the board. At least to get their perspective becomes important for me. So that, because currently their staff is blocked to perform some duties, etc., etc., and no one else would explain properly to us exactly what is happening. And I'm talking about an urgent matter. Yeah. Because the King would have his own perspective on the matter. How do we balance those perspectives at that point in time? I understand the logic of members, and I fully agree that we can meet them anytime. But the problem, there's a crisis now that some workers can't get into and perform their duties because of the interference of the King. Because now I've got a right to say the King is interfering because it does not have the power to dismiss. I'm just persuading.
Honorable Matizan.
Chair, we are going to meet the stakeholders, not our entities. If we want to invite the board, we can invite the board anytime. I strongly believe that, I strongly stick to my guns that I don't think it should be part of this oversight visit, stakeholders that we are going to meet. And in any case, we are going to get the briefing from the minister before our oversight visit in terms of the status of the board. And we can also invite the board here. I don't see any reason why we must go meet our own entity out there. The purpose of the oversight is to meet stakeholders, not our entities.
Any other takers or contributors to the discussion? Because I would hate if we have to vote on this one. we must just discuss and reach consensus on this one. Honorable Mkhaga.
No, Chair, let's park the matter until we meet the minister. Upon being briefed by the minister, I'm not sure, Minister, whether he's going to meet the board or not. Not sure. But the minister might tell us the state of affairs as far as the board is concerned, and then on the basis of that, we take a decision around this particular item. But
yeah, I would have agreed with Honorable Mkhaga to park the matter. However, there is a problem of us having to plan for this and also give those people time also to do their own plans to accommodate us. So that if we wait until the 21st, when we would be leaving on the 23rd, then it would be very, very short notice. Yes, Honorable Bosso.
Chair, if I remember correctly from when we had the Zoom meeting, I don't know if it was you who said so, but somebody said that the king is aware of the fact that we would also be meeting with the board and that he was fine with it, but that the sequence was important. And maybe if we could just refer back to that, that seems to me to lead the way. I mean, if he was aware of it when we would have visited him back in January, I can't really see why it will muddle the waters now if we still meet the board. But maybe you could just repeat what you said at that stage.
I'm not sure whether I will be able to do so now, but I'm thinking that you see we are on a fact-finding mission. We want to hear everybody involved in this. We will be meeting the king. Our first port of call will be with the king, then other stakeholders. Now, the major issue here is between the king and the board. Now, we will come back with an incomplete picture, having not met with the board. That is my view. I'm not actually, deciding the matter, but I'm looking at it from that kind of angle, that being on a fact-finding mission in an impasse there that actually exists now, we go and meet with the king, and then he says what he wants to say to us. I see absolutely no harm in us meeting with the board at some later stage of our oversight visit, having met with the king. But also what Honorable Matigizela is saying also is valid. Well, that is in terms of time management. If we don't, we will not be able to afford the Ingonyama Trust Board ample time to actually engage and interact with us, then we should consider meeting them at some other time. But my only concern is that we will come back with an incomplete picture, because it's one thing meeting them as part of the usual oversight, responsibility. But on this particular one, it's for the specific, reason and purpose, because of the impasse that exists in the operations of Ingonyama. But we are meeting again next week. We can actually bring the matter back, having actually slept over it. And that is how I look at it. If we can pack the matter, then come back next week, having slept over it, and taking all these considerations into account. Did I see a hand?
So I was saying, Honourable Chair, I think your summary is okay. We may now not know whether should we miss an opportunity to meet with the board, the extent of them being barred from accessing not only the building, but even the resources. How severe that ban is on them. Will they be able to fly or drive from KZN to Cape Town? So it's something maybe between now and when we meet again, the committee should find out and advise us accordingly. Thanks, Honourable Chair.
Well, thank you. Is there any other matter? Well, I think we have exhausted our agenda for today. Thank you so much, honorable members. Thank you for your contributions and inputs, especially on the legal opinion that was presented to us. Thank you so much. The meeting is adjourned. Is there any lunch? There will be lunch next time, not today.